Hello and welcome to this second OTB Legal webinar. Today we'll be talking about sponsor duties and reporting requirements. Just to give you a little idea of the format of today, we're going to talk you through what your basic requirements are in terms of reporting duties, and then at the end there will be the option to ask questions. We would ask you to put the questions either in the chat or in the Q&A section, and please be aware that this is a public arena, so any other delegates who are attending the webinar will be able to see your questions, so make sure you don't include any kind of sensitive client information in there. I'm with my name's Sally McEwen, and I'm with my colleague Lydia. Hello. And in the background, we've got my other colleague, Sam, who is dealing with all of the Q&A and any kind of technical issues that you have. So if you want to put anything into the chat, he will be able to see that. So as I said, today we're talking about reporting requirements for existing sponsors. Now, as a sponsoring organisation, you get the benefit of international employment. So the Home Office expects you to take your responsibilities towards your sponsor duties very, very seriously. And it's really important that you are aware of your reporting conditions and obligations. Some of them are subject to quite tight deadlines, and it's important that you are familiar with them. As we've said on previous webinars, the Home Office do operate on a light trigger approach to licence revocation. So it is really important that you as a sponsor understand all of the requirements for reporting for your workers and any changes in your business structure. So I am going to deal with changes to licenses that need to be done in 10 working days. Now, the 10 working day deadline starts from the date of the event. So you'll see on the slide, if your sponsored worker doesn't start their role, so if they don't turn up for their first day of employment, that is the event, the date of the event, and you need to report that 10 working days later. There may be circumstances where you need to report it, but you will continue to sponsor that worker if they've missed their flight, or where there's some compassionate reason why they've not started. But if they don't turn up, then you just need to report that within 10 working days. If your sponsored worker is absent without permission for 10 working days, then again, that needs to be reported, and the date of the event is the 10th day that they have not attended for work. There are permitted absences, so parental leave, maternity leave, paternity leave. If your worker's taking part in some kind of humanitarian aid exercise, or if there's legally organised strike action, they are permitted and you don't have to report that. It would be quite unusual if your employee's contract ends early in the date shown on the certificate, but if it does, then again, you need to report that on the sponsor management system. And the relevant date in that case is the last day of employment, so the 10 days from the termination date. If you stop sponsoring your worker for any reason, then this also needs to be reported. And this kind is an all-encompassing provision, really. So if your worker switches to a different immigration route, for example, if they become dependent as a spouse, or if they switch into indefinite leave to remain, you need to report the date that that switch happened. 10 working days is the date of the event from which they switched into a different route, and you will need to enter the last known address and details about your migrant worker when you make that report, so the Home Office is aware. Significant changes to your employee's role. So if your employee is promoted, but they remain in the same standard occupational classification code, for example, that needs to be reported as a change in circumstances. The Home Office aren't very interested in reporting pay rises, but they are very interested in a reduction in pay, particularly when it becomes less than the salary that was entered on the certificate. And you need to be careful that you're not reducing pay to lower than the appropriate rate for that standard occupation classification code. And in those cases, you will need to stop sponsoring that worker. If your worker changes the standard occupational classification code, that doesn't result in a report. You actually need to do a change of employment application with a new certificate for that worker. Where your sponsor has changed, but the work remains the same, this can take place where a company's taken over and there is a TUPE transfer of workers. So you would need to make a report within 10 working days on the old sponsor management system to say that your workers moved to a new sponsor, and that sponsor will be the new owning entity. And that kind of covers that sponsored worker is affected by a TUPE transfer, but that all needs to be reported for the individual employees, as well as reports that Lydia will go into in relation to the change of ownership for the business. And then finally, this is one of the new routes, the scale-up worker. If you're sponsoring a scale-up worker and you have this new scale-up license, you'll need to report the date on which they start working for you, because the sponsorship of a scale-up worker is limited in terms of the time that you have to sponsor them for. So those are the kind of 10 working day reports that you have to make in relation to your sponsored workers. And I'm now going to hand over to Lydia to deal with the changes to the company.
Thank you very much, Sally. Slide on. Okay, so Sally has been talking about changes that have to be reported that relate to a sponsored worker themselves. Pretty much all of those have to be reported within 10 working days. I'm going to be focusing on changes that you have to report that relate to the sponsor as an organisation. The majority of these, you have 20 working days from the event taking place to get them reported. There's one exception to that. So if as a sponsor you change from being a small business and become a medium or large business, or vice versa, if you're a medium business and you become small, or if you either gain or lose charitable status, that's supposed to be reported within 10 working days. A small business, for these purposes, you will qualify for the small business if you can tick sort of two of the following boxes. So it's an annual turnover of 10.2 million or less, total assets of 5.1 million or less, or 50 employees or fewer. So if you can tick two of those boxes or more, then you will be classified as a small business for these purposes. The reason that you have to report this is because it affects how much you pay in fees to the Home Office for things like the immigration skills charge or the cost of the renewal fee when you come to renew your licence. Realistically, identifying the precise day on which you change from being a small business to being a medium business, for example, is quite tricky, I think. For a lot of sponsors, in reality, this isn't something that's all that likely to happen. If you're a very small business and you're clearly miles away from having 50 employees, for example, then it's maybe less of a concern. Equally, if you're a very large sponsor and you're clearly going to remain in the medium or large regime for the foreseeable future, it's not so much of, it maybe doesn't need to be so much of a concern. But if you know, for example, you're a small business, but you're currently growing quite rapidly, then this does need to be something that's on your radar. I would certainly be considering whether you do need to make a report at the time when the company is producing its annual accounts for the year. And also, if you are about to sponsor a worker, for example, and you know that you may have crossed that threshold, it would probably be worth reviewing at that time. Pretty much the rest of the things that I'm going to be looking at, you have 20 working days to report. So it goes without saying that you would need to report to the Home Office if you change the name of the sponsor or the name of any of the branches. I'm talking here primarily about the formal legal name of the organisation. So if you're a company, then the name of the company's house. If you're a charity, the name that you have registered with the Charities Commission, for example. When I refer to branches in this context, I'm talking about branches that are listed on your sponsor license. Some of you may have licenses with lots of branches. Some of you might not know what I'm talking about. So a sponsor license can be structured to reflect the structure of your organisation. So if you're a small business, one limited company with no subsidiaries, that's fine. You don't need to be worried about it. But some businesses might have, for example, a parent company with a number of subsidiaries underneath. And in that scenario, the parent company can obtain a license and add the subsidiaries as branches on the license. In that scenario, that's helpful because it allows the parent company to sponsor workers on behalf of each of their branches without each of those individual subsidiaries having to obtain their own license. So it's an option that's there, but if any of the listed branches or the company name change, that needs to be reported within 20 working days. You'll also need to report if you either cease trading or enter any kind of bankruptcy or insolvency procedure. What will happen if that does happen in that scenario is that usually the Home Office will downgrade your license to a B grade. What that means is that you can continue to sponsor your existing skilled workers to facilitate either the orderly wind up or the resolution of the insolvency procedure, but you will not be able to sponsor anybody new. If you are involved in an insolvency procedure, then the insolvency practitioner will typically be granted access to the license and be appointed as the authorising officer, and they will be expected to administer the license for as long as is necessary. The next few that we have got listed here on this slide, we've listed them as separate things so that you're aware that each of these things are something that has to be reported. But the key thing that we're looking at here is anything that involves any kind of change of ownership within the business or within the sponsor. So that could be if you're involved in a merger, an acquisition, if there's any kind of change of ownership. So that could include, for example, if there's a change in the immediate ownership of the sponsor. So if you have a license for one company within a larger group, and this happens frequently, the corporate lawyers insert a holding company immediately above the company that has the sponsor license. So there's a change in the immediate ownership of the sponsor. Even though it's a holding company that's not really doing anything, you must report that on the sponsor license. It also includes if you're selling all or part of a controlling number of the shares in an organisation. If you're partly or wholly taken over by another organisation, or if you're doing the opposite, if you're demerging essentially and splitting out to form two or more new organisations. All of these things are things that will have to be reported. There's a few things to be aware of with this. The first is that the regulations and the guidance around things like mergers, acquisitions, change of ownership is very, very complicated. It's one of the most complex areas that you will deal with as a sponsor. So if you know that any of these things are on the horizon, I would strongly advise you to take advice well in advance and get some help from a specialist in the area. That can be us or any other organisation to advise you before it happens, if at all possible. Very often when you report these things, that will not be the end of it. The Home Office will very often want additional evidence and documentation to be submitted to them for consideration. There can often be quite a lot of that depending on the scenario. So it's helpful for you to know that in advance so that you've got time to get that paperwork organised before you make the report, rather than being scrabbling around to find it afterwards and it taking you by surprise. The third thing to be aware of is that in some of these circumstances where there's a change of ownership, the Home Office will actually require a new sponsor licence application to be submitted. So they will often do that if there's a change in the direct ownership of a sponsor. They tend to be less concerned if there's a change in ownership that's sort of higher up the chain, if you like, in the corporate structure. But very often a change in direct owner will require a new sponsor license application to be submitted. What then happens, assuming that that sponsor license is granted, is that any sponsored workers you have are able to just be transferred from the old license onto the new license. And that's important because it means that the workers themselves don't need to make new applications for new skilled worker visas. They're existing, they can stay on their existing visas, and just the responsibility and the reporting responsibility for them transfers over to the new license. There will be cases where that is not permitted. So where workers are TUPE transferring, for example, typically you are able to transfer them directly from one license to the other. But in scenarios where there is no TUPE transfer, that is not always the case. So this is another reason why it's really important to take advice on these issues at an early stage, so that if you do think workers may need to submit new applications, that can be communicated to them in good time, and you can ensure continuity then, both for them and for you. Following on from that, it's also the case that a sponsor license is not transferable. So if you are taking over a company and that company has a sponsor license already and they're sponsoring workers on it, you can't just take over the running or the administration of that license. You would need to report the merger or the takeover to the Home Office, and if you don't already have a license, they're likely to say that you need to apply for one, rather than simply taking over the administration. The key thing to sort of bear in mind with these is the reason why the Home Office are doing this. So the Home Office are interested in who's named on a license, but they're also interested in who actually has positions of power and control within an organisation, who is actually in a position to pull the strings behind the scenes. And the reason they want to know that is they want to know if someone who they would not consider suitable to be in charge of a license is seeking to obtain access to a license sort of by the back door, if you like. So that's their logic, and that's why they will sometimes require you to apply for a new license if they want to run checks or if they have any concerns about who may be taking over ultimately responsibility for a license. It goes without saying that if the sponsor is an organisation, or if any of the key personnel are convicted of certain criminal offences, that also needs to be reported fairly quickly. They're listed in Annex 4, but typically these are immigration related offences. So convicted of knowingly employing illegal workers, for example. There are other things that are not specifically listed within the guidance as reports that have to be made within a certain time frame, but nonetheless, there are changes of circumstances that you will have to communicate to the Home Office, and you will do it through the SMS. So whilst technically they may not all be covered by your reporting duty, realistically, they feel like reporting duties, and I tend to think of them in that way, which is why we've included them on this slide for you. Big one that causes a lot of issues is changes in key personnel. So when your authorising officer leaves, or your key contact leaves and someone new takes up post, you must make sure that you are updating the identity of those individuals on the SMS in good time. You must also always make sure that you have at least one level 1 user in post. We would always advise having more than one level 1 user, so that if one person does leave or is off sick, is unavailable for any other reason, you can still access the license and operate it effectively. Equally, if a level 1 user does leave, you must remember to deactivate them. your level 1 login is not a Netflix login. You must not share it. Just as with the owners of the business, the Home Office are also interested, and they're running background checks. When you add a level 1 user, an authorising officer, they're checking those people before they grant them any kind of access to the license. And that is why they react very badly if they find that you're sharing a login. It's one of the key things that can lead to compliance and enforcement action on the licenses, things like not having all of your key personnel in post, or people sharing using other people's level 1 logins. Changes of things like trading name and also addresses. You need to report both of those again through the SMS. Again, the address could be your registered head office address, or we could also be talking about if you move office. So if, for example, your Manchester office moves to a new building, you need to report the new address. You'll often find with this that you'll end up actually changing the address multiple times on the SMS. So, for example, if your Manchester office moves to a new location, you will need to report the change of the Manchester office as a site. If your authorising officer is based at the Manchester office, you also need to update the work address of the authorising officer separately. And if you've got sponsored workers working in the Manchester office, you'll also need to report the change in their work address. So it can, again, that's an issue that can catch people out, and it's important that all of those addresses are up to date so that the Home Office know where they would attend in order to speak to any of those people at short notice, should they wish to. Other things on the screen: if you want to appoint or remove a legal representative, you can have a legal representative named on your license, and they can then become level 1 users, for example, or a key contact. Those need to be kept up to date. If you need to remove a branch or a site for any reason, that is something you will report ideally quite quickly on the SMS. Any changes to your accreditation body, if that's something that's applicable to you, or if you need to make your license dormant or surrender it for any reason. All of those are factual changes that you would need to report through the system. So I think the key takeaway points from this webinar for you are, first of all, this is a lot easier if you keep on top of these organisational changes and ownership changes in particular as you go along. For smaller sponsors, it's not such an issue often, but it's still something you need to be aware of. For your larger sponsors, where you do have quite a complex corporate structure, it's really helpful for 1 or 2 people in the organisation to really make sure that they understand what needs to be reported, so that you know if any of these issues come up, that you can address them in good time. It is always helpful to conduct regular reviews of your SMS to make sure that all details are up to date. You should log into the SMS at least once a month. That's because the Home Office posts sort of updates to all sponsors on the front page, and they do sometimes check how often sponsors are logging into the SMS. But equally, an annual review to make sure that anything that you have forgotten, anything that has slipped through the gaps, can get mopped up at that point. Is worth doing. Finally, it happens that inevitably some of these things don't necessarily get reported within the time limit. All the things about changes of ownership, mergers, acquisitions, etc., can very often catch people out. It's something that we hear about and advise on quite often. It is almost always going to be better to report something late than to just hope that the Home Office don't ever notice and not report it at all. So most of these issues can be resolved if they are addressed as they come to light, and if addressed correctly. So don't put your head in the sand, don't panic. If you do think that there's an area of concern, take advice and just seek to deal with it now, and arm yourself. Forewarned is forearmed, as I say. In terms of our services, obviously, if you do have concerns or if you need advice on sponsor compliance, the team here all specialise in that area, so we're very happy to provide one-off advice or ongoing advice. We can also assist you with all other issues or applications that you might need to make relating to business immigration in general. Our services are on the side there. And should you need to contact us, you can do it through any of the usual methods. You can always contact us by email. You can visit our website and you are able to book an appointment through that directly with a member of the team. And you can also find us on the usual social media channels. The webinar today is being recorded, so you will also be able to watch it back if there's anything that you want to catch up on. And that's all we've got for today, but I believe we have some time for questions.
Okay.
Thanks,
Just
Lydia.
gonna stop sharing the screen so that we can see your lovely faces. We have had a few questions through.
Okay.
Just to kind of remind people, these are public questions, so everyone can see what you put in the chat. So just as a reminder, as people start to come up with their questions, please don't put anything that's time sensitive in there because other people will see it. If there are any questions that we feel we can't answer because they're too specific, so that does occasionally come up. If we have your details, we'll make a note to get in touch with you after the meeting. And equally, if we don't, because I know some people have managed to ask these questions under an anonymous name, then I will type an answer to you just to ask you to get it, either provide me with your details or to kind of get in touch with us at our contact email. So the first couple of questions we got relate to kind of change of circumstances for employees.
Mm-hmm.
So where you have somebody who has long-term sickness, so they've been signed off by their GP, what other reporting duties that relate to that? Do they need to report that on the system? And how quickly do they need to do that?
So I think it probably does need to be reported. It will depend on, a lot of things will depend on how that employee is retained, I think. So if it's long-term sick and they're not going to come back to work, then they're not really sponsored anymore. Long-term sickness is not on an exception, but where the exceptions arise, it's about unpaid leave. So if they're still being paid, then they should be all right, they're still sponsored. But I do think we would need to know more about the circumstances of that particular employee, and that's certainly something we can get back to people.
Yeah. So obviously kind of long-term then it really depends on the situation. If we're talking a few weeks.
Yeah, a few weeks probably doesn't need to be reported, but it will, again, it depends because it's about unpaid leave. If it will depend on your kind of terms and conditions and the what contract you have with your employees, and so yeah, it's not, there isn't a kind of catch-all answer to that. Would you agree?
Yeah, so you may well have to report a reduction in salary, for example, and that's where it's going to depend on your terms and conditions. Are they off sick on full pay? Are they on half pay, for example? Those are the sorts of things that you would need to take into account.
Yeah.
Okay, and this one also relates to absence specifically.
Mm-hmm.
So if you and I believe this refers to holidays. So this person asked about leave. Based on the context, I'm assuming you were referring to annual leave. So if somebody takes more annual leave than is normally reported on the SMS, do they need to update that?
You don't report annual leave on the sponsor management system.
Well, we're talking about kind of disclosed in contracts and working conditions. So the answer to that presumably would be no.
No.
Yeah. When you have somebody who is kind of coming to you and they are pregnant, and they enter your employment, they're already pregnant, and they haven't disclosed that to you when you hire them. They later disclose that they are pregnant and they want to work from home until they are granted, until they give birth, and you've sponsored them on the basis that they're working from the office. Is that a change in circumstance?
Yeah, I think that probably oversteps the remit of what we're able to advise on. That seems like much more of an employment issue to me.
In terms of whether that permissible under employment law, that's you might want to speak to someone about that. From an immigration perspective, if you've said if what this basically is a change of work location, then the key thing would be if to add potentially their home address even on the SMS as either their main or their secondary work address. That would be, from my perspective, that would be the key thing to do.
Yeah, but I don't think that, just in terms of what they've told you and things at the start of the employment is not something
That's not something that we can
comment on.
advise on. If that's a concern, I think you need to speak to someone who can advise on employment law.
Okay, and this one kind of forms, it's not really a reporting duties question, but it is a sponsor management question. And it's more about kind of employee care. So where somebody, you're no longer sponsoring somebody, so we're talking about curtailment. Where somebody, you're no longer sponsoring somebody and they're whether that's redundancy, whether that's been sacked, and you have reported that, you've reported that within the timescales. What effect does that have on the employee?
So where an employee's contract has been terminated and you have reported that on the sponsor management system, that report will trigger a curtailment letter that would go directly to your now ex-employee. In terms of your responsibility towards that employee and your sponsorship license, once you've made that report, you don't have any other responsibilities towards that employee. It's quite difficult to kind of give any accurate timescales about when curtailment letters are issued at the moment. So although that report on the sponsor management system is the trigger for a curtailment letter, we are seeing significant delays in those curtailment letters being issued to ex-employees, but those letters will go directly to your employee and you have no further responsibilities in relation to what happens to that employee once that report has been made.
Where you have somebody who you were sponsored, they've not yet begun employment, and they apply for their skilled worker visa, and then that visa gets refused for kind of whatever reason, that's Part 9, where that's other issues. What reporting duties do you have in that situation?
So in that situation, you would report that your employee has not turned up for work, basically. So that's it. You've got a start date on your certificate of sponsorship. They will not turn up for work on the day that they are due to start work because their visa has been refused. So you report on the sponsor management system that your worker has not started their employment, and you set the reason as they've been refused a visa, and that's the end of that report.
And this is a similar delayed start, so I would assume the answer here is going to be pretty similar, is where an employee starts significantly after the date on their COS, and the delay is due to the employer rather than the employee. Does that have any impact on the duties?
You need to report delays in start dates where they are significant. It can be quite difficult to manage the whole process, because if you're applying for a skilled worker visa for somebody to have entry clearance to come in, then you apply for that certificate on the sponsor management system, and at the time that you make the application for the certificate, you put in your start date and you put in the end date for that employment. Then things happen between you being granted the certificate to it being assigned and your worker applying for entry clearance, and there's lots of reasons why there are delays. If the certificate has been assigned but not been used in an application for entry clearance, and there is a delay to the start date, you can add a sponsor note to the certificate to say that the start date's been delayed. If the certificate has already been used by your employee and it will show as used in the system for entry clearance, then you add a sponsored a worker change of circumstances to say that the start date has been delayed.
What are the time limits on this reporting? I don't mean how quickly do you need to report it, but in terms of these delays specifically, so how long can a start date be delayed?
So it's normally 28 days. It'd be quite unusual for you to go beyond that 28 days, I think. But lots of things happen that are outside of employers' controls, especially at the moment, where we are seeing significant delays in decision-making timescales from the Home Office. So, you know, for example, we've had one recently where we've paid for a priority service and it's actually taken 6 weeks to get the decision in. So that's way beyond the 28 days that we would normally kind of report on. And in those circumstances, we are just updating the sponsor management system, you know, every couple of weeks, and then trying to work out what a realistic start date would be for that employee based on, you know, these significant delays that some applications are facing at the moment.
So we've had a couple of questions on a slightly different tack about remote working. So if you have an employee, obviously entry clearance application, they're coming into the UK from overseas, and you've sponsored that worker and their visa is currently pending. Can that individual start working for you from overseas remotely? And if so, does that need to be reported?
Oh, that's a good question.
Okay, so this is off the top of my head. This is a cautious answer, and I would stress that I think if they're still overseas and they're not physically in the UK, I think that they probably can start working because they're not physically in the territory. However, you may want to take advice about the effect of having employees working remotely in another jurisdiction. And if, for example, that incurs tax liability in that jurisdiction, or whether you then have to comply with employment law regulations in that jurisdiction. That's not something that we can assist with, but just be aware that there are other complications around it.
There are, you know, potentially some other issues as well. If they're working wholly remotely, then why do they need to be sponsored to come to the UK in the first place? There may be arguments about, you know, time differences and why somebody needs to be here particularly, but we don't advise companies who sponsor people in the UK to have their sponsored staff on a 100% remote working contract. It's far better to have a hybrid working arrangement, even if it's just 1 day a week in the office where there's contact.
And we've had a couple of people ask questions on that vein in terms of both people who have yet to start and people who are already working for them who would like to work remotely from overseas. I'm just going to say to both of those people, because they have asked these questions anonymously, so I don't have their details. If those people please can contact us at hello@otb.legal if you would like to take advice on the immigration law aspects, and we can talk to you about that in a bit more detail. I just had a pop-up that's blocked the questions, bear with me. So if you've got an employee, so it's a fairly nice and straightforward question, an employee who you sponsored, and as we all know, when you're filling out a certificate of sponsorship, you put their passport details on.
Yeah.
If that employee later, during that period of employment, gets a new passport, do you need to report that new passport number?
Not in the sponsor management system. Yeah.
This kind of goes back to Lydia's comments about not to panic, but if somebody's just gone, a company has just gone slightly over the kind of, whether that's a 10 working day limit, whether that's a 20 working day limit, depending on the type of reporting, to report a change of circumstances, how serious is that breach?
I think, as Lydia said before, you don't need to panic about these things. That a late report is better than no report at all. what we would suggest in those circumstances is to get some advice, because what you kind of ideally want to do as an employer who has a technical breach of their duties is present the report when you do make it to the Home Office in its most positive light. So I think it will depend on the report, and yeah, I mean, I would definitely say get some advice, get some help about late reports and kind of putting a positive spin on it.
Yeah, and it's going to depend massively on the circumstance. You know, if
Yeah.
you missed a report by 24 hours, that's very different from having missed 20 reports by 3 years. And I've come across both of those things, and I've dealt with both. So how serious it is depends on what it is that you've not reported, how many reports haven't been made, and how late they are.
So we just got a couple of people asking about the recording, just to reiterate what was said before. This recording is going to go up on YouTube, so you will be able to watch this back again.
I think that the recording, actually, for everybody who's registered today, the recording and the slides will be sent at some point next week, I believe.
So I'm gonna set you up for a question that we all have fairly strong views about. Employers know currently that there are significant delays from the Home Office. That kind of, I'm going to ask the question that they asked us, and I'm also going to add my own aspects to that. So the question we received was, why do the Home Office not communicate with employers? And the kind of follow-up to that is there anything that employers or potentially employees can do about this?
So the Home Office, I think, don't communicate with employers because it's just too big an organisation, and much of their kind of customer services elements, particularly in relation to UK visas and immigration, has been outsourced to private companies. Those private companies do not have access to Home Office systems, and you know, it's not just employers that the Home Office ignore; they ignore us as well. You know, we send email after email after email on delayed cases, and very rarely do we get a response. Complaints are taking months to deal with. The Immigration Law Practitioners Association is getting involved with the delays and making reports to kind of quite high up in the Home Office to see if we can get some improvement in the system. But there's very little anyone can do, actually. It's frustrating for employers, it's frustrating for employees, it's frustrating for us, because there's just no real certainty in the immigration system at the moment. We can't say for definite when your application will be decided, and there doesn't seem to be any rhyme or reason as to when particular applications are decided and when some aren't. You know, our experience is similar to yours as employers. And what was the next bit? Sorry, then.
Was there anything that people can do about that?
Not really. I mean, it's just, you know, you can write to your MP, you know, and your MP can put pressure on the Home Secretary. They can raise questions in Parliament, but in terms of kind of contacting the Home Office and speaking to somebody is almost impossible at the Home Office, and you know, a lot of the email addresses just go unmonitored as far as I can tell at the moment.
Yeah,
you've got.
I have the same experience. I say the Home Office is, whilst ability to communicate with them has never been
Brilliant.
perfect,
Yeah,
it is especially bad at the moment. And sometimes, you know, you think you must be doing something wrong that that you haven't heard anything back, but that's not necessarily the case. Unfortunately, everyone's in the same boat.
Going back to reporting, does disciplinary action against a sponsored employee count as, does that count as a significant change in circumstances that needs to be reported? And, you know, if so, obviously this is going to be nuanced. So what is the level of?
I think it will probably
disciplinary
depend on the outcome of the disciplinary action. You know, there's no, when you log into the sponsor management system to undertake your kind of reporting duties in relation to your employees, there's a drop down menu of various different things that you can report on. Disciplinary action is not one of them, and you wouldn't report the action itself on the sponsor management system. But if the result of that disciplinary action is a dismissal, then obviously you would report that. If it doesn't result in a dismissal, then there's nothing to report, and everything in your sponsored worker will carry on as they had before the disciplinary action.
Okay. We've got a couple of questions on the same theme that I think it's not strictly a reporting issue, but it again relates to employees starting work and feeds into the delays issue. And there has been a recent change in the immigration rules on this, where you have students who are moving from a student visa to a skilled worker visa. Are they able to start working on their skilled worker visa before that has been granted? And what are the specific circumstances that allow them to do that?
So students are allowed to work if as long as they're at a university that's government funded and has a history of compliance. They should be allowed to work 20 hours a week during term time and full time at any other time, so during holiday and when their degree is finished. So presumably companies are employing students when they've finished their academic studies and are waiting for their graduation. In that period when they're no longer studying, they're able to work full time, and then they can switch into the skilled worker visa, and you will then have those reporting obligations towards that person as a skilled worker. What you should be doing just in terms of your own records is ensuring that you have the students right to work checks and they've all been conducted properly, that you've got a central record of their leave expiry date to make sure that you're not employing them without the skilled worker visa beyond that leave expiry date, because then they'll become an illegal worker, they'd be an overstayer. So I think that answered the question.
Yeah, right to work checks would be the key thing.
Yeah.
Okay, just a couple of sponsor license admin questions. We've not too many more regarding reporting duties specifically. Is there any issue with an authorizing officer and a level 1 user being the same person?
No. And you'll find with lots of small companies that your authorizing officer and level 1 user and key contact are all one and the same person. It's probably sensible to have an additional level 1 user, as Lydia said earlier in the presentation, even if your authorizing officer, initial level 1 user and key contact are the same person, just so if that authorizing officer leaves, you've got somebody who still has access to the system. Yeah.
Okay, sorry for the slight silence. I'm just seeing whether there's any other reporting questions that we haven't answered already. There are a couple of questions that are slightly too specific for us to answer.
Okay.
Yeah, I have made a note of who's asked those, and I will get in touch with them afterwards. And we have a number of questions left over that I will try and put to you as we have a bit more time. They don't strictly speak to it, but okay. Again, this very much relates to kind of going back to delayed start date. So this is a question we've answered a little bit already, but where where the company's made a mistake or situations have changed and somebody's start date on their COS is before they've even attended a biometric appointment or submitted their visa application. So these things happen. What are the reporting duties on that?
So again, if the COS has not been, if the certificate's not been used, then you can add a sponsor note. And what you need to bear in mind really with the certificate is once the certificate, if it's a certificate for entry clearance, it's valid for 3 months from the date that the Home Office grant you that defined certificate. And once it's assigned, it's valid for another 3 months to support the application for entry clearance. But obviously your start date might be wildly different if there are things that are beyond your control that you weren't aware of when you applied for the certificate, and you can't change the date on the certificate because that's auto-populated when it's granted. So yeah, I mean, if it's not been used and the person hasn't attended their biometric appointment, then it will just be sitting in the system as an unassigned but unused certificate, and so you can just add the sponsor note to that certificate. And then what should happen is that when the entry clearance is granted, the vignette will reflect the sponsor note with the delayed start date on it, rather than the start date of the original certificate when it was applied for.
Yeah. In that scenario, the other thing I'd say is when the worker does eventually get their visa, just double check the date, just in case the sponsor note has been overlooked, for example, just to make sure that they're getting the correct period of leave.
Yeah.
Okay, and in terms of extensions, again, company sponsors a worker, that worker has applied for an extension, they are facing a delay and their current leave expires. Can they continue work?
Yes, absolutely. So provided they've made an application for the extension before their skilled worker visa expired, they will be protected by Section 3C leave. Now, Section 3C leave operates, extends leave to remain automatically under the Immigration Act 1971. So where your worker is waiting for a decision on an application that was made before their leave expires, their current kind of conditions just are extended until the decision is made. There is, what you should be doing is a new right to work check after the leave has expired to make sure that application has gone in. So you won't be able to do that with a share code. I think you need to log in or Google the Home Office right to work check and then put their details in, and you should be able to get confirmation that that person still has the right to work for you while their decision is pending.
And does that apply to all sponsored work groups? Not just kind of skilled worker, so kind of creative worker,
yes,
religious worker.
Yeah.
Okay, that answers all of the kind of open questions we had. I'm very aware for those still with us that there are some people who have questions in the Q&A that I have not answered. I am not ignoring any of you. That these are fairly specific questions that I've made a note of who you are, and I will get in touch with you either later on today or next week.
Fabulous. Excellent. Well, thank you very much, everybody, for signing up and joining us today. And we hope you have a lovely weekend.